We are live.
Hey everyone, my name is Kendra Hunter. I'm with Dental HQ. Thanks so much for being here today. We are diving into a great topic, the FTC's new click to cancel rule. If your business offers subscriptions or recurring billing, this one is definitely for you. I'm excited to introduce two experts from Holland Knight who are here to help us figure it all out. Brian Goodrich is a regulatory attorney who helps companies stay compliant with consumer protection laws and defends them when the FTC or other agencies investigate. And Genn is a pro at helping businesses navigate everything from automatic renewals to subscription compliance and enforcement actions. We're so lucky to have them with us today. Let's jump in.
Wonderful. Thank you so much, Kendra. And good afternoon to everyone on the East Coast and like myself in the Central Time Zone. And good morning to everybody in Points West. I am going to share my screen. We've got a lot to cover today on this important and evolving topic. Let me get my slideshow going. Fantastic. All right, today's topic is the FTC's new click to cancel rule. This is a brand new regulation that's been wheeled out by the Federal Trade Commission, and it applies to all companies that offer recurring subscriptions and auto-renewing sales, companies across all industries. This is one of the things that the FTC has chosen to focus on in these last couple months, and we're expecting them to be actively enforcing it coming after July 14th. So today during this presentation, we're going to cover what you need to know, stay compliant and stay out of the crosshairs of the regulators and out of the crosshairs of the class action attorneys. Before we dive into the rule itself, let me give some quick background on who my colleague Ben and I are. We are lawyers with the law firm Holland Knight. Holland Knight has over 2,000 attorneys in 40 offices across the United States. I'm located in Holland Knight's Dallas office. Ben is located in our Washington, D.C. office, where I used to practice before I became a Texan. Also, this slide has our phone number and our email address. We will be taking questions throughout the presentation, so if you have questions, please feel free to drop them in the chat. We will pause periodically to take them, and then at the end, we'll try and get to as many as we can. And then at the end, we'll pause and we'll leave some time. So feel free to type in your questions, and we may not get to them to the end, but we'll try and answer all that we can today. But if we don't get to your question, or if you have a more involved question or want to talk, here's our contact information. Take it down or reach out to Dental HQ. They will have it as well. Getting a note that my screen is on the cover page. Let me see if I can move forward. Ben, have I moved forward to the agenda page?
I think you need to do from the beginning.
Okay. Excuse me just a moment. That is what I did last. Hold on.
No worries.
From beginning.
Perfect. Yep.
Are you now seeing the second slide with our contact information?
Yes.
Yes. Seeing the
All right, there we go.
There we go.
So
Perfect.
here's that contact information that I was just referencing. Okay, let me move along. All right, let's talk about what we're going to cover today. First, we're going to provide some background. What is this new rule and why are we having to deal with it? What it was the impetus for this, the FTC's decision to wheel this out, and why is it doing it now? Second, we're going to talk about what types of businesses and what types of sales are subject to this rule. Spoiler alert, it's everybody that offers a recurring subscription or an automatically renewing product or service. But we'll go into more details to what that means for you. Then we're going to talk about what everyone wants to know. What are the requirements of this new rule? How do we comply with it? How do we stay out of the crosshairs of the regulators? And then we're going to talk about there's a challenge that's been filed against the rule that is playing out in the courts, as well as what we see in the future coming from the FTC. The Federal Trade Commission has already brought us a lawsuit against Uber for some violations that are very similar to the types of violations that this rule covers, foreshadowing that it's going to be a very active couple months in this space. And then lastly, Ben is going to talk about some changes that are coming to California. If you sell online and you have a presence in California or California-based customers, there's a law in California that's changing in July that has some supplemental requirements. So we thought it'd be helpful to include that in this presentation. And then, as I mentioned at the end, we will take any questions that we weren't able to get through during the presentation. All right, one quick slide, one quick disclaimer. Today's webinar is meant to be educational. It's not meant to provide legal advice or counsel. That you have to engage us and we have to run a conflicts check. That is the rules of professional responsibility that lawyers operate under. So take this information as educational. All right, let me start with some background. What is the click to cancel rule? Well, the Federal Trade Commission, the regulatory agency that is headquartered in Washington, D.C., and has been around for 100 years or more, regularly develops new consumer protection regulations. So these are rules meant to protect mostly consumers defined as individual people, but also sometimes small businesses. And this is one of those instances when that's important because this rule applies to both B2C sales or business to consumer sales, as well as B2B sales, business to business sales. So this is a very broad consumer protection regulation. And again, this was wheeled out earlier in the year. It was supposed to take effect today, but just recently on Friday, the Federal Trade Commission voted to postpone it for 2 months to give businesses 2 more months to get ready for it, to understand how it's going to apply to them, understand its requirements, and then change their sales processes, cancellation protocols, and disclosures as needed. It is notable here that the FTC chose to postpone it for 2 months when the FTC has the authority to fully withdraw the rule or fully postpone enforcement. We have seen some of that in this space by the Trump administration since they took office in January. It's notable that they did not do that with this regulation. They only postponed it for 60 days. So that signals to us in the consumer protection space that after July 14th, this is going to be a regulation that the Trump administration plans on enforcing. Now, there are some prior rules in place, particularly in the telemarketing space. Some also select online sales. They've been subject to other rules. Some people on the call may be familiar with the telemarketing sales rule or the Restore Online Shoppers Confidence Act, ROSCA. If you know of those rules, you'll hear some very similar things in this rule. Essentially, this rule tries to take the requirements in those older laws, bundles them all together, and instead of having them apply just in telemarketing or just in certain types of online sales, it wheels them out applying to all recurring and automatically renewing subscriptions and sales. So that's the intention, is to take the old laws and juice them and make them a lot stronger and a lot broader. We're going to talk in this presentation. This rule is going to provide for additional disclosures to your customers. It's going to require you to get additional consent, make sure your customers are filling out additional checkboxes, and is also going to address how consumers need to be able to cancel recurring subscriptions. As I mentioned before, this rule applies both to B2C and B2B sales. So if you are thinking about your contracts and you're thinking about, individual customers, it's not just them, it's also customers that are businesses or agreements you have with other businesses, such as support providers, admin support providers, and have agreements, software providers that automatically renew. All of those are within scope for this rule. And last but not least, this rule, the FTC likes it a lot because it allows them, unlike some of their other regulations, to go straight to the courthouse if they think someone is violating the rule. For a lot of other rules and regulations, the FTC has to undergo administrative hearings and administrative processes before they can seek relief. This rule, that is not the case. And this is why one of the reasons why we think the current FTC is looking to enforce it after July gets here, because it allows them to go straight to the courthouse, sue companies that it believes are not complying with it, and get court orders that say they must comply with it going forward. And they can also seek penalties and refunds. So they can seek refunds for recurring fees that were collected without the proper permissions. And they can also seek up to $53,000 per violation. Worth noting in this moment that a violation is a sale that does not comply with the law. So every time someone makes a purchase and they did not provide their consent, or they did not receive the proper information about the recurring nature of the subscription, that's a violation and entitles the FTC to seek up to $55K in penalties. Last piece of background, why are we dealing with this? Why is there a new rule? What is the FTC trying to do here? Well, according to the FTC, over the past 5 to 10 years, they have received a lot of complaints from consumers and from customers that say, hey, I've gotten trapped into this recurring subscription that keeps charging me. I've sent emails, I've called, I've tried to cancel, but no matter what I do, I keep getting charged. Also, consumers that complain and say, hey, I signed up for this. I thought I was buying 1 month of this service, but then I just checked my bank account. And it turns out over the last 12 months, these recurring fees have been taken from me without my knowledge. Those are the two types of complaints that really has brought this rule to be. The FTC has a database called the Consumer Sentinel, where consumers can submit these complaints, and the FTC collects them, aggregates them, sees where are the problems in the marketplace, and tries to go after them. So this is one of the areas that they've chosen to focus on. Again, they're also focusing on it because it's easy for them to run to the courthouse on this one. And there's bipartisan support for addressing these violations. The press release on Friday that said we're postponing this rule for 60 more days and then we'll begin to enforce it said the Trump-Vance FTC is postponing this and then we'll begin enforcing it. So though this rule was written by the Biden administration, the Trump administration and its appointees at the Federal Trade Commission had made clear that they are going to enforce it. So something really to be aware of. All right, I'm going to turn it over to my colleague Ben for a moment, talk a little bit about the scope of this rule.
Thank you, Brian. Yes. So you may be wondering what exactly is a negative option, which is synonymous for an auto-renewing recurring sale or transaction. In this instance, what the FTC rule means is an agreement or arrangement that continues on unless and until the consumer requests to cancel. In other words, the agreement takes the customer's silence as acceptance to continue on providing the good or service. Think gym memberships, phone plans, streaming services as one type of, or rather the most common type of automatic renewal. And there are also 3 other types that fall expressly within the FTC's rule here. One is a continuity plan, such as a weekly meal delivery service that continues until the consumer cancels. Another is essentially a free trial service or a free to pay or a fee to pay conversion. So think of your streaming service that says you can stream our music ad-free for the first month. Thereafter, we'll charge you a certain amount on day 31. The last type is a pre-notification negative option plan. In the old days, it'd be a delivery of Netflix CD or a music CD. Today, think delivery of water or other goods that are sent. And unless the consumer expressly rejects that delivery, then the recurring sale or recurring shipment will continue. Importantly, the negative option, the definition of negative option in the rule does not include installment contracts. And those are where, as you may be familiar with, consumers are obligated for the entire contractual period unless the installment, and the rule does not apply unless that installment contract contains an auto-renewing feature or the negative option feature. And one thing to mention here is that this rule encompasses sales in any medium. Brian mentioned ROSCA, that dealt with online transactions only. Here, if you're transacting online, in person, over the phone, those are all encompassed by this rule. Think also chat, text message, SMS, any method you use to conduct sales will fall within this rule. So what relevance does this have to you all watching today? The rule likely applies to membership medicine, concierge medicine, and other subscription-based models to include telemedicine. This will also include business-to-business support contracts and arrangements such as DSOs, other vendor contracts, your contracts with physicians and other self-referrals, Medicare contracts, unless those unless those are not renewed, because they automatically renew, as you may know. And the rule will also apply to individual and group health insurance that continues at year end or at the end of that term unless canceled. So this applies across a broad range of industries, healthcare included, again, in any medium that you use to conduct your business, be it with a consumer or with another business.
Right.
Brian, back
Next
to
we
you.
want to- Thank you so much, Ben. Next, we want to talk about some of the requirements. Let me just pause and ask my colleague Hannah, are there any questions that have come in at this point?
No questions so far, so you guys can continue if you'd like.
Excellent. No, we'll head into the meat and potatoes of this. This is the requirements that are going to take effect and be enforced after July 14th. Okay, first and foremost, the rule requires that certain information be provided to the customer at the time of purchase. And more specifically, it's actually got to be prior to collecting billing information. So before you ask for someone's credit card information, debit card information, etc., whatever payment information you accept, there's certain items that have to be clearly disclosed to the potential customer. So first, you've got to disclose the recurring nature of the purchase. That not that they're just signing up for a one-time purchase, but that this is a recurring obligation, and it needs to describe like the nature of that recurring obligation. Is it a monthly obligation? Is it a quarterly obligation? Is it an annual obligation? That's one of the most important things that the FTC wants to see disclosed. Second, and this particularly, I think, applies in light of the free trial conversions that Ben just mentioned. If there's a deadline where the customer has to act or else they will be charged, that has to be disclosed up front. So as Ben mentioned, to use his example, someone signs up for a month of ad-free Sirius radio, but after a month, they're then charged $4 or $5 a month, so on and so forth. But the customer has to be told, you can cancel on day 29, but on day 30, when the free trial ends, the next billing period starts and you will be charged. That has to be disclosed up front. You've also got to disclose how much it's going to cost. What are they agreeing to? What are they agreeing to pay? Important note here, it's really got to be the full price. It can't just be the price and then, oh, there are also some fees that are also charged every time, and that's not disclosed. No. That's got to be disclosed up front, including also things like taxes. If there are taxes that are going to be added on to the fee and charged every month, if they're going to substantially affect the price, then that needs to be disclosed. If it's a very, very minor amount, it's not really going to affect whether or not someone wants to purchase this, then the rule does give some flexibility on that. But some jurisdictions, some purchases, taxes can be quite substantial. So in that case, the amount of the taxes that will be charged each time have to be disclosed. And if it's impossible to give the exact amount, because taxes may vary depending on what state you're operating in, then you have to provide an estimate and say, you'll be charged each month $30. And in addition, taxes will also be charged in a range from $1 to $3 depending on what jurisdiction you're in. And then importantly, you have to disclose how the customer can cancel and get out of the recurring obligation. Do they have to go online to their dashboard or account and click a button that says, I want to cancel my subscription? Do they have to call your customer support hotline? Do they have to send a letter? However you require them to cancel, it's got to be simple, and Ben's going to talk about that in just a minute. But however you require them to cancel has to be disclosed prior to the agreement to make the purchase. And then lastly, but definitely not least, the FTC's thrown a little catch-all in here. Again, because this is an attractive rule to them, they can run right to the courthouse if they think someone's violating it. And that is essentially, there's any important aspect of the purchase that needs to be disclosed up front. So, for example, I'm going to jump on one of the water deliveries that Ben mentioned on a prior slide. If, for example, those deliveries will only be made on Sundays, then that probably is something that needs to be disclosed during these disclosures. If it's something important, something that would affect someone's decision as to whether or not their product or purchase is right for them, that needs to be disclosed up front, or else they could run afoul of the requirements of this rule. I mentioned timing a little bit, but I want to hover it over it again because it's really important. Again, before the customer provides their credit card, debit card, Apple Pay, PayPal, Venmo, whatever, however you're soliciting payment, before you collect that information, you have to provide the disclosures that I just mentioned. Now, if you're wondering, how does this apply to existing customers? Some people have existing customers and they sign up for new products or services, or they sign up for a new level of service. Can I use the information I already collected? And the answer is yes, but you've got to include those pieces of information that I just mentioned. And then you have to say, by clicking purchase, I'm agreeing that you may use the billing information that I've previously provided. So again, you've got to provide that updated, those updated disclosures about the important information about the recurring service. And then you either solicit the billing information you need or get permission to use billing information you've already got on file. Okay. Now, one more slide on the disclosures themselves. So I've told you about the content. I've told you about when they need to be shown. Now, they also need to be clear and conspicuous. For those who've dealt with the FTC before or are aware of the space, you've probably heard this before. This is a standard that the FTC uses when it talks about how something must be clearly and how it must be disclosed. Essentially, what clearly and conspicuous means is that the disclosures have to be unavoidable and easily understandable to your customers. This is a flexible standard, so clear and conspicuous can mean different things in different contexts. But essentially, what does this mean? This means that it's got to be bold. The it can't be buried in fine print. It cannot be buried on page 10 of a terms of service agreement. It's got to be right. If you're doing an online purchase, it's got to be right on the web page as part of the checkout process. If you're doing something on the phone, again, it's got to be clearly stated, the same speed. You can't rush through it. The people have to be able to understand it. Now, the rule does accept that in this modern day and age, we have purchases being made on our phones and via applications, where instead of a big web page, or instead of someone talking to you on the phone or even meeting you in person, a lot of times we got these little tiny spaces in which to present disclosures. If that's the case and you've got an app or you're doing things on your phone, it is okay to use hyperlinks to say, here are important recurring disclosures, and then have someone hyperlink to it, or have a little pop-up come up on the phone that says the disclosures, and then someone has to press X to continue. Typically, that is not allowed. The FTC does not want important disclosures like this buried, again, on page 10 of a terms of service. So this is a standard online transaction. You're going to want to see it prominently displayed during the checkout process. But if you're working in a small space, they're willing to be a little flexible with you on that. Couple more things important perhaps to this audience. Number one, if you are selling to the terminally ill or to the elderly, to children or teens, then you need to take account the level of understanding that those customers bring to the table. So clear and conspicuous, for example, what that could mean in the context of elderly customers, probably going to require some level of large print. Even fine print is definitely not going to work for that crowd. And then even normal size print, sometimes that presents challenges. And if you know your customers have certain difficulties associated with accessibility and with viewership, then you need to take that into account. It's, again, clear and conspicuous. It's a flexible standard. It's what stands out, and it's unavoidable for your customers or your anticipated customers. And then lastly, if you offer your services or advertise to a population that doesn't speak English, or English is often their second language, then the FTC is going to want to see you translate those disclosures into the language of your intended audience. So again, it's just about making sure that what you're saying is understandable to the people that you intend to purchase your product or service. Ben, let me pass it over to you.
Thanks, Brian. So let's talk about what we mean and what the FTC means by express informed consent. As a business or a seller, you must clearly and conspicuously disclose the important information, as Brian mentioned, prior to obtaining your customer's billing info. And you can't charge a customer before obtaining the express informed consent to the negative option feature itself, or to the auto renewing feature itself, not just to the contract at large or the agreement at large. That's a critical piece. And the consent must be separate from the rest of the transaction, meaning the consent must be solely for that feature, and it can't be combined with your terms of service or the privacy policy, for example. And the disclosures Brian mentioned must be immediately adjacent. The FTC uses the term immediately adjacent. And as he said, that means on the same page, as close to or next to as the disclosures themselves. And a lot of you may be wondering, we have a lot of requests coming in as to whether or not a checkbox itself is required. The answer is yes and no, or maybe it depends. And it's to be seen what the FTC's enforcement looks like following July 14th. But generally speaking, and in compliance with the California law that we'll talk about, along with some other state laws, a checkbox usually is a more assured way of complying with the rule and staying out of the regulator's crosshairs. Now, the FTC does state you can use a checkbox, signature, or substantially similar feature to confirm the client's express or the customer's express informed consent, and provides a safe harbor for those. It's to be seen exactly what the FTC expects unless and until the first enforcement action under this rule comes about.
I would agree, though, with Ben's description of that usually a checkbox is what they're looking for. That I think that is by and large what the FTC expects here. And whether that's a checkbox on a computer screen, a checkbox, or a signature acknowledgement on a hard copy piece of paper, but typically that's what the FTC wants.
Right. Thank you, Brian. And one point behind that is the FTC does understand that there's different technological barriers depending on the method you're using. Is it an app in space constrained spaces? Do you have to scroll, or is it a long form on a desktop? It's dependent, but it's safe to say a checkbox is better than no checkbox. And we can move to the next slide, Brian. And one piece, sorry, if you could go back, please. I did omit that the rule requires you to maintain records of the consent itself for at least 3 years. So does the California law, several other laws. And that's, again, to the acceptance of the negative option feature itself, not just a record of the consent to the agreement at large. Perfect. Thank you, Brian. Now, the eponymous name, click to cancel, or the simple cancellation. What exactly does that mean? It usually looks like a simple user flow, at least on an app or a desktop or some sort of profile sign in, with a cancel or confirm cancellation button without any barriers to that cancellation. Now, importantly, the rule does not prohibit saves or discount offers prior to initiating the cancellation, but you can't put up unreasonable or unduly delay the cancellation process through multiple rounds of saves and offers, or making the customer call back or use another method to cancel. And critically here, the FTC means a simple, easy to use mechanism through the same medium that the consumer consented to the auto renewal itself. So if they signed up online, they need to be able to cancel online. If they called in and initiated the transaction, you made the sale through the telephone, they also need to be able to call in and cancel through that way. And if the consumer signed up again through the phone, if they sign up online, you can't require them to call in to cancel. They have to be able to cancel online. And think here, for practical purposes, a clearly labeled cancellation button within the user's account or somewhere within the account settings, the membership plan should be that button to cancel. You also must immediately stop the recurring charges once the request to cancel comes in, subject to a save offer or a discount offer, something like that. The requirement is to cancel the auto renewing feature, but also stop the charges. That's the critical piece here. And as I mentioned, saves, discounts are allowed. So is verification or authentication of the user, usually done by logging in to an app itself or, confirming some of your information when they're calling in. That's permitted. Obviously you can't, have 3, 4, 5 steps to verify identity in effort to delay the cancellation. Reasonable authentication is permitted. And that's all on this page. Thanks, Brian.
Excellent. Before we go on to our next topic, which is what we anticipate the FTC to do and how it to be enforced, I noticed there's some questions. I know we fielded a little bit, some of them so far, but Hannah, I was wondering if you could maybe read us a couple of the questions that have come in.
Yes. Perfect. I'm going to read it, Melena's. Does this rule apply even if the service provider doesn't have a way to auto charge the customer, i.e., we don't collect any credit card, we just invoice the customer each year and they choose how to submit payment?
Interesting. That's a good question.
Brian, I can take this.
Okay, go ahead.
Sure. The answer is yes. It applies regardless of whether you're using a credit card to charge a consumer, invoicing another bank account, or submitting a paper invoice. And that's based on the definition of negative option seller in the rule. And some of the commentary in the FTC's rule talks exactly about this. And they also talk about another question that I think is forthcoming, but the short answer is yes, it still applies. Otherwise, that would sort of negate the purpose behind the rule.
Right.
Perfect. Thank you, Ben. We have another question. If we resell another company's services, could we be liable if the third party hasn't made it clear to the client we are billing? Are we responsible for making sure the third party has updated their contact?
Another good question. The short answer is you could be. Yes. So the FTC is going to look at everybody who touched that transaction, both the seller and the person who's facilitating that transaction. I think that the person, if they were not actually providing the service, they have a good argument that they shouldn't be the person that's held responsible for providing refunds or for paying any penalties. But I don't think the FTC is going to make that distinction up front. They're only going to make that distinction after they've sent a letter, conducted an inquiry, asked for more information. At that point, you've already had to hire counsel and spend a lot of money. So I highly recommend that folks who work with third parties in that manner work together to make sure that everybody's compliant.
Perfect. Thank you, Brian. The 2 questions we have.
Yeah, if I may, Hannah, I would agree with that. And that's exactly what the FTC talks about, because some commentators brought that up exactly. And the FTC basically says, well, that would encourage, if you will, companies to work with actors who aren't acting above board or bad actors, so to speak, and work around the rule, defeating the purpose. So as Brian said, yes, best to stay above board and ensure those that you're working with or on behalf of are complying with this rule.
Right. And I'll also just add one more thing that we also expect after the government gets in, now that the government is really in this business, We also expect class action and private attorneys to follow right behind, and they will definitely not make a distinction. They will just sue everybody who's associated with the transaction. So it's better to err on the side of caution on this one.
Awesome. Thank you, Brian. Thank you, Ben.
All right, let's talk about challenges and enforcement. We would be remiss if we, after we've talked about all the requirements of this rule, if we did not know that there's a challenge to it that is working its way through the Eighth Circuit Court of Appeals. In this challenge, a number of trade associations have sued the FTC to try and prevent this rule from taking effect and prevent the FTC from enforcing all the requirements that we talked about. Now, if that challenge is successful, then this rule could be completely discarded. However, practically speaking, my humble take here, or maybe not so humble take, is that that's not going to happen here. I think the court is going to hear it, and there is certainly a chance that the court could agree with the challengers. However, the challengers asked the asked the Eighth Circuit Court of Appeals back in December to stay enforcement, to issue an order saying this rule will not go into effect until we've decided the case. And the Eighth Circuit refused to do it. Notably, that's not been the case with some other FTC regulations. Maybe on the call, you're familiar with the fact that the FTC a couple of years ago issued a rule banning non-competes throughout all industries. That one is being challenged, and that challenge remains ongoing several years in. And that one, the courts stopped and said, while we figure this out and whether or not it's legal, we're not going to let this rule take effect because we agree with the challengers that letting it take effect would cause harm. And so, though the challengers here have said letting this rule go into effect while we're deciding this challenge will cause harm, the court doesn't seem to have agreed with that assessment and has not issued a stay. But essentially, the trade associations that are challenging it are arguing that these requirements are too burdensome for business. It's too confusing for industry to figure out what requires a checkbox and what is a negative option. It said the FTC has gone beyond its authority, and they've made a series of other arguments. Again, interestingly enough, the Trump-Vance FTC has continued to support its case in the appeal, meaning they are arguing that the rule is a proper use of the FTC's authority and should be allowed to take effect. So I think it's highly unlikely that the challenge could be successful, but as I'm not a justice on the Eighth Circuit, I can't speak to that. So it's possible that it could be stopped, but it feels unlikely at this point. And also why perhaps this feels unlikely is that the FTC has already started to make some moves in this space. The biggest lawsuit was just filed 2 weeks ago. The FTC sued Uber. Again, under a different law, ROSCA, we mentioned it a couple times, but this is one of the laws that this rule was modeled after. And essentially, the lawsuit was kind of a warning to industry that this is what it could look like. The FTC has argued that Uber misled customers that signed up for its Uber One recurring subscription service. And it said people didn't realize that when they signed up for this free trial, or when they signed up to buy it for a month, they didn't realize that it was going to be a recurring obligation. Uber did not make that clear enough when it was in the app, when the person was making the purchase. The FTC also goes to great lengths to allege that Uber made it very difficult for people to cancel the service. They hid the cancellation button in the account area under a series of settings that none of which said cancellation. And then if you were lucky enough to find that, the FTC alleges that you had to navigate sometimes up to 20 screens before you were permitted to cancel. Uber would ask you, or at least the FTC alleges that Uber would ask, do you want to stay if we reduce the price? Or can you give us some feedback on why you're canceling? And then the FTC alleges that customers kept answering the questions or would try and get out of answering the question, and then that would negate their cancellation attempt, and they'd find themselves stuck in it. And they'd look back at their bank accounts and see, in fact, even though they had tried to cancel and had pressed the cancellation button, the cancellation had not been effectuated. Also, the FTC alleges that Uber was making people call, and even though they were signing up on the app, they were forcing some people to call in. And then it took, again, the FTC alleges Uber is going to fight this in court, but the FTC alleges that sometimes it took Uber up to 2 days to call people back and to effectuate their cancellation. And in the meantime, while they were working through that, Uber was still charging people. And that's what this rule is meant to stop. It's meant to say if someone reaches out and tries to cancel, you need to stop the recurring charges. Even if you need to verify their identity or you want to reach out and ask questions, you can't keep charging them in perpetuity. That's what the FTC is trying to prevent. There's another company that they also sued. This, unlike Uber plans to fight this in court. They disagree with the FTC's allegations. There's another company by the name of Clio AI, a cash advance company, and they settled out. They agreed that they had trapped some customers into a recurring membership, and they've agreed to pay the FTC $17 million that the FTC is going to distribute as refunds. And Clio AI negotiated a settlement where they will be agreeing to change their business practices permanently and remain under FTC supervision for a number of years. So these signal to us that the FTC is very serious about this rule and really has gotten a lot of complaints over the years from people that can't get out of their subscriptions and they're tired of it. So it's just really prudent. I'm glad you all are here today because it's really prudent to be paying attention here. Before we head to California, Hannah, I think I saw one more question come in. Do we want to cover that quick?
Yes, we have one from Dave that says, if the customer signs an annual agreement but is being billed monthly, does this give the customer an ability to opt out of the annual agreement early, even if the negative is the annual contract is the renewal agreement?
Good question. Typically, now if it's an annual agreement and they're paying monthly, then typically it's an installment contract. So typically, installment contracts are not covered by this. There is a little bit of wiggle room here, though. If that contract has a provision that says it automatically renews at the end of those 12 months, then yes, this is going to apply. So that's my read of this. Installment contracts, it is a little bit of a gray area, and we're going to see how aggressively the FTC enforces this rule. It's possible they could take the position, but if it's the term of the contract is annually and they're just paying in monthly installments, then no, the rule is not going to apply. Ben, you disagree with anything there? Or would you say anything different?
No, that's right.
Excellent.
Perfect. We do have one more.
Sure.
Anonymous asks, is there a difference with the regulations for annual renewals versus monthly renewals?
No, this applies to both. And the only major difference would be in the disclosures. Instead of saying this purchase you're about to make, is a recurring monthly purchase, you just have to say it's a recurring annual purchase.
Perfect. I think that's it for now.
Excellent. All right, Ben, I'll toss it over to you.
Thank you. And I know we touched on a bit of California law earlier, but we're gonna hit it now and dive a little deeper. So as I mentioned, California has a very stringent auto renewal law. It's actually broader than the FTC's rule itself. And so if you take nothing away from this slide, it's that California's law and some other states are, because they're broader, it's a good bet that if you're doing business in California and across all 50 states, you'll want to comply with California's law, and that should cover most of the FTC's rule requirements, as opposed to the inverse, where if you're only complying with the FTC's rule, you'll likely miss some of the requirements under the California amendments that go into effect in about a month and a half, starting July 1st. And an important part with the California amendments, remember, California already has an auto renewal law. They're just amendments that take effect on July 1st, and we'll get into that. But this will apply to a contract entered into, amended, or extended after July 1st, 2025. So any customers under contract that you have right now, once that term auto renews, whatever the term is, once that auto renews after July 1st, it will need to be compliant with the rules here. And you'll need, again, express affirmative consent from that customer. So the amendments to this specifically pertain to, again, free trials. It loops in the free to pay conversions, as we already mentioned. And California's piece is a little more stringent than the FTC's rule in that the consent to the free trial and to be charged after the free trial needs to occur at the time of the initiation of that free trial, not on day 29, 28, 30, what have you. It's at the time of initiation when the customer signs up for the free trial itself. In other words, you need consent to charge the customer thereafter, after the free trial, when they sign up for the free trial. Again, checkbox here. There's a group called CART. It's an acronym, CART, California Auto Renewal Task Force, and it's states attorney general from various counties, mostly in Southern California, but they all band together and look at what's going on in California and any businesses not complying with the rule. Their enforcement actions to date show that they essentially require a checkbox. And that's why we mentioned earlier that a checkbox is usually the best bet here when it comes to the FTC and California. Like the FTC rule, it also requires cancellation in the same medium as the consumer signed up. If it's online, there needs to be a simple mechanism to cancel online, telephone to telephone, email, you get the idea. You'll also need to maintain the consumer's consent to the auto renewal feature for at least 3 years or 1 year after the contract is terminated, whichever period is longer. That's a slight variation from the FTC rule. And similarly, discounts and saves are permitted under the California rule. But unlike the FTC rule, there are a couple differences. This California rule only applies to business to consumers, not B2B, not business to business. And sellers also must provide an annual notice of the terms, the product details, the charge frequency, and how to cancel, or the cancellation means. That varies from the FTC rule. You'll also need to provide customers with a notice of material changes in any of the terms to the auto renewal. So think a price increase the next month or at the next term, whatever that term may be. You'll need to provide additional notice of what that change will be and when it'll go into effect. And then above and beyond what the FTC requires, the California law, the amendments at least, will require an acknowledgement email of all the material terms of the auto renewal contract, the contract and the auto renewal piece, as well as how to cancel the auto renewal. So a lot of you may already do that. And in our daily lives, you probably signed up for Netflix and immediately got an email. Here's, how much we're charging you and when and how to cancel. The reality is most of you may already do that just as good business practice, but now the California auto renewal law amendments will actually require that. And again, the takeaway is because the FTC rule does not supersede any state laws unless it's inconsistent with those state laws, anyone doing business across all 50 states would be wise to comply with not only the FTC rule, but the California piece and other state auto renewal laws like New York, Colorado, Virginia, Georgia, so on and so forth. And the final piece is that we expect not just California, but other state AGs to actively enforce their own auto renewal laws in addition to the FTC enforcing their rules. And I lied, that was the penultimate piece. The final piece on this, in addition to class actions, is we've seen in California, while the law can be only enforced by the AG, him or herself, we've seen private plaintiffs bring actions for violations of the auto renewal law under a UDAP claim, under an unfair and deceptive trade practices claim, under a false advertising claim. And that's how they sort of dovetail an auto renewal violation into a broader Consumer Protection Act violation. And that's all.
All right. That is the meat of our presentation. If you have additional questions, please throw them in the chat. I'm gonna put it back also and put us back on our contact slide. If you have questions after this that you think of that you didn't ask now, please feel free to email or call Ben or I, and we're happy to talk more.
We do have one more question that was submitted. I'll go ahead and read it out loud. What about recurring payments that are set up as an in-house financial arrangement, separate or in addition to an in-house dental membership plan?
Interesting. Sorry, I'm struggling with the term in-house a little bit. I'm taking that to mean this is a fee. Sorry, could you read that question one more time, Hannah?
Yeah. What about recurring payments that are set up as an in-house financial arrangement, separate or in addition to an in-house dental membership plan? So these are offices that are having their own membership plan rather than having insurance be involved.
My sense is that the rule would apply here because I don't think the in-house nature of these would negate just the general, hey, there's a negative option here. There's an agreement in place that renews automatically unless someone affirmatively cancels. So my understanding of this is that those types of contracts would be subject to the rule.
Perfect. Thank you. I don't see any more questions unless anyone wants to submit any within the next few minutes. But thank you guys so much. Thank you, Ben. Thank you, Brian, for all of your help and for all this information. I really do appreciate it. And thank you everyone for registering for this webinar.
Thank you, Hannah. Thank you, Kendra, and thank you everyone who joined us today. We appreciate it.
Awesome.
Thank
All right.
you.
We're going to leave it at that. Thank you again for everything. And I will send out an email with the slide deck, correct, Brian? And the webinar replay.
Great.
Perfect.
Have a
Awesome.
great day, everyone.
Have a great one.
Thank you.
Thank
Bye-bye.
you. Bye-bye.